Welcome to the deep dive. Today we're getting into a really fundamental and frankly quite difficult area of criminal law. The insanity defense.
Yeah.
This isn't your typical guilty or not guilty situation. It's really about this deep question. How does the law distinguish between someone who should be held criminally responsible and someone whose mental illness is so severe they need, well, care instead of punishment?
Exactly. That distinction is the whole point. And it's vital for you to grasp the outcome here. A successful insanity defense means a verdict of not guilty by reason of insanity. But that almost never means walking free. It usually leads to mandatory commitment, often for an indefinite period, in a secure mental health facility. So our job today is breaking down the legal tests used for this critical determination.
Okay, let's unpack this then. The sources we're looking at focus on the two main approaches you'll see in U.S. courts. There's the older, more restrictive M'Naughton test, the right-wrong test, which is heavily focused on cognition, what the person was thinking. And then there's the more modern ALI test from the Model Penal Code, the substantial capacity test. It's broader, brings in volition the ability to control actions. Getting the elements precise is really the key here.
Absolutely. Precision is crucial when the law tries to map the complexities of the human mind. We should start with the bedrock, the rule that still holds sway in most places.
Right, the foundation. That's the M'Naughton rule from way back in 1843. Let's ground this in the case that started it all. We need to analyze M'Naughton's case. So first things first, what are the legally essential facts?
Okay. Daniel McKnighton, back in 1843, was experiencing significant paranoid delusions. He genuinely believed he was being persecuted by the Tory party, specifically by the Prime Minister, Sir Robert Peel. He set out to assassinate Peel, but, in the case of mistaken identity, shot and killed Peel's private secretary, Edward Drummond. The defense argued his delusions meant he didn't understand the wrongfulness of his act.
And the core legal issue that this terrible event raised for the law.
The central question posed to the judges by the House of Lords was essentially, what legal standards should we use to acquit someone based on an insane delusion like M'Naughton's? Their answer created the famous right-wrong test that carries his name.
Okay, so what rule of law did the court establish? Can you state the full black-letter rule and then break it down into its core testable elements for us?
Certainly. The M'Naughton rule states that an accused is not criminally responsible if, at the time of committing the act, they were laboring under such a defect of reason from a disease of the mind as not to know the nature and quality of the act he was doing, or, if he did know it, that he did not know he was doing what was wrong. It sounds dense, but you can break it down into two main requirements the defense has to meet. First, the disability element. There must be a defect of reason stemming from a disease of the mind. Second, the result element. That disability must cause the person to lack knowledge about either, one, the nature and quality of the act, or two, that the act was wrong.
Thank you. That helps clarify the structure. Now, for the court's elemental analysis, let's walk through this piece by piece. How did the court interpret that first element, disease of the mind? What qualifies, and maybe more importantly, what doesn't?
Well, the initial scope is quite broad. It can cover severe mental conditions like psychosis, neurosis, even things like PTSD. But importantly, the rule is designed to distinguish illness from, say, bad character or voluntary choices. So it specifically excludes things that aren't seen as pathological mental diseases. Think simple moral failings, fits of passion like insane jealousy, or, crucially, temporary insanity caused by getting voluntarily intoxicated.
That makes sense, separating involuntary illness from voluntary actions or just bad temper. I noticed our sources mentioned that the federal statute based on M'Naughton added a word. How did they tweak that disease of the mind element?
Right, they added the qualifier severe mental disease or defect. This was a deliberate policy move, really, to narrow the defense further. It aimed to exclude less profound conditions, things sometimes labeled personality disorders, or maybe less debilitating neuroses. The idea was to reserve the defense for cases involving a truly significant break from reality.
Understood. So, a high bar for the first element. Let's move to the second element, the cognitive failure part, the lack of knowledge. Can you analyze the first possibility here? Not knowing the nature and quality of the act. What does that phrase actually require?
This prong focuses on the physical reality of the act. Does the defendant understand what they're physically doing and what the direct physical consequences will be? For example, do they understand that hitting someone with an axe causes severe injury or death, not just, say, a mild bump? If their delusion makes them perceive the act as something physically different or harmless, they might meet this part of the test.
This is where we get those really stark, memorable examples. The sources often mention the hypothetical defendant who strangles his wife but genuinely believes he's squeezing lemons. How does that bizarre scenario illustrate this nature and quality element?
It's a perfect, if disturbing, illustration. Because of the delusion, the defendant lacks awareness of the physical reality. They don't comprehend the nature of the act strangulation or its quality causing death. They think they're performing an innocent action, squeezing fruit. So they satisfy this prong of ignitin. It's interesting because this is a place where the insanity defense clearly overlaps with a lack of the necessary mens rea, the criminal intent. They just don't know what they are physically doing.
That really highlights how profound the cognitive disconnect needs to be for this part of the test. Okay, let's tackle the final alternative element. Lacking knowledge that the act was wrong. Now, wrong seems ambiguous. Does it mean legally wrong or morally wrong?
And that ambiguity is a major point of division. It genuinely depends on the specific jurisdiction. In England, where the rule originated, wrong generally means legally wrong contrary to the law. However, in the United States, most courts that have directly addressed it lean towards morally wrong. And this isn't the defendant's personal morality, but rather wrong according to objective societal standards of morality.
Okay, but hang on. If the standard is societal morality, what about that classic scenario? The defendant knows killing is against the law, but they are acting under a delusion, maybe believing God commanded them to do it. How does the morally wrong standard handle that?
That's where the critical exception comes in. The deific decree exception. Many U.S. jurisdictions recognize this. If someone kills because of an insane delusion that a divine power ordered them to, they might be found not to know the act was morally wrong, even if they are perfectly aware it's illegal. The delusion essentially overrides their moral compass in the eyes of the law in these jurisdictions. It's a key point to watch for.
Got it. The deific decree exception is crucial for the moral wrongfulness test. So, bringing it all back to the original case, after analyzing Knighton's own delusions about Peel and the conspiracy, what was the final conclusion in Magnet's case?
The jury found Daniel McKnighton not guilty by reason of insanity. Implicitly, the finding was that his paranoid delusions were so severe that they prevented him from understanding the wrongfulness of his actions. He was then committed to a mental institution, fulfilling the defense's aim: diversion from criminal punishment to medical custody.
Okay, so Knighton establishes this cognitive knowing test, but its big criticism has always been that focus purely on thought. It asks, did they know, but ignores the possibility that someone might know an act is wrong but be completely unable to stop themselves, the irresistible impulse idea. How did the model penal code try to address this limitation with its alternative test?
That's exactly the gap the ALI test developed for the model penal code that's MPC section 4.01 aimed to fill. It introduced the concept of substantial capacity. The rule states, a person isn't responsible for criminal conduct if, at the time of the conduct, as a result of mental disease or defect, they lack substantial capacity either to appreciate the criminality or wrongfulness of their conduct, or to conform their conduct to the requirements of law. You can see three really key differences emerge there compared to McKnighton. First, it requires only a lack of substantial capacity, not the total incapacity McKnighton seemed to demand. Second, it uses the word appreciate, which is broader than just know. And third, crucially, it adds that volitional prompt, the inability to conform one's conduct to the law.
Let's break those down. First, the cognitive part. What does using the word appreciate achieve that no didn't capture under McKnighton?
Appreciate was chosen very deliberately. It's meant to encompass more than just intellectual awareness. It includes effective understanding the emotional and moral significance of the act. So, under Knighton, someone might know they're firing a gun. Under ALI, the question is whether they could truly appreciate the gravity of taking a human life. This opens the door for richer, more nuanced psychological testimony about the defendant's actual mental state.
And the volitional part, inability to conform conduct, directly tackles that irresistible impulse problem. But the drafters must worry this could open the floodgates, right? Especially for people who just repeatedly break the law or have what used to be called sociopathic traits. Was there a safeguard built in?
Yes, a very important one. Section 4.01, subsection 2, explicitly defines what doesn't count as a mental disease or defect for the purposes of this defense. It specifically excludes conditions that only manifest as repeated criminal or antisocial behavior. This was put in precisely to prevent the defense from being used by individuals diagnosed, for instance, with antisocial personality disorder, the so-called psychopathic personality. The idea is their issue is primarily behavioral or characterological, not a quality qualifying mental disease in the sense needed for this defense.
That's a crucial carve-out. It really clarifies the shift. And not focusing purely on rational thought, ALI incorporating the capacity for rational action. Okay, this has been a detailed breakdown. For the listener trying to synthesize all this, maybe for an exam or just to get a clear handle on it, how can we structure this into a step-by-step checklist for spotting and analyzing insanity defense issues?
Absolutely. We can build a practical, step-by-step diagnostic framework. Think of it like this. Step 1, rule identification. First and foremost, what test does the relevant jurisdiction use? Is it Knighton? Is it the LMPC test? Or maybe some kind of hybrid? That dictates everything that follows. Step 2, mental disease defect. Is there evidence of a qualifying disease of the mind or mental disease or defect? And critically, is it potentially excluded based on policy? Think voluntary intoxication, mere passion, or, under the ALI test, that psychopathy exclusion we just discussed. Step 3, M'Naghten analysis, if applicable. If M'Naghten is the rule, you then ask, did the disease cause a cognitive failure? Check A, did the defendant fail to know the nature and quality of the act? Think physical consequences, like a lemon squeezing example. Check B, or alternatively, did the defendant fail to know the act was wrong? Remember to consider if wrong means legally or morally wrong in that jurisdiction, and don't forget the deific decree exception if moral wrongness applies. Step 4, alien PC analysis, if applicable. If the ALI test is the standard, you ask, was the defendant's substantial capacity impaired regarding either prong? Check A. Was their capacity to appreciate the criminality or wrongfulness substantially impaired? That's the cognitive affective prong. Check B. Or, alternatively, was their capacity to conform their conduct to the law substantially impaired? That's the volitional prong. And step 5, the result. If the requirements of the applicable test are met under either M'Naghten or ALI, the verdict is not guilty by reason of insanity, leading to commitment, not prison.
That framework really lays it out systematically. It underscores just how challenging it is for the law to draw this line between criminal culpability and profound mental illness. Thank you. That was an incredibly thorough analysis of these core doctrines.
Glad to walk through it. Ultimately, this whole M'Naghten versus ALI debate isn't just legal hair splitting. It reflects a deep philosophical disagreement about what legal responsibility even rests on. Is it purely about rational thought, the cognitive capacity M'Naghten emphasizes? Or does it also require a capacity for rational action, the volitional control that ALI brings into focus? It's a fundamental question.
And that leaves you, the listener, with something to consider. When the insanity defense succeeds, it leads to commitment, which achieves goals like public safety through restraint and potentially treatment. But how does finding someone not guilty because of illness align with other goals of punishment, like retribution, the idea of just deserts or general deterrence? When the law excuses conduct due to profound mental illness, what balance are we striking between societal protection, individual justice, and the broader messages we send about responsibility? That's a tension that remains at the heart of this defense.